Oh, there says that all attendees are listen only, but it started. Did you touch something?
You must have hit a button.
Yeah, now everybody can hear us, Wendy.
And it says being recorded.
She can stop the recording.
Okay.
Hello, everyone, and welcome to MacroPro and Friends. We're coming to you live from the MacroPro studio. Today, we're hosting a special edition of MacroPro and Friends, and this is one of many webinars we're hosting to add to our portfolio of educational events and opportunities for our clients and for our friends. Today, we will be talking about coronavirus and its effects that it's having on all of us in the claims industry. This is an important part, not that all of our presentation is important, but this, I really need people to pay attention to this part. I get a lot of email. This presentation today is 1 hour of CEU credit in the state of California. If you have logged in via your registration confirmation, a certificate will be emailed to you within 36 hours of this presentation. If you're calling in, you need to join us via your confirmation. Go back to your emails, look at your confirmation, and go ahead and log in. And this is what's going to generate that certificate. Your certificate will arrive approximately 36 hours after this webinar. So everyone's logged in. Today, we have 4 panelists who are joining us, and they are all experts in their field. First, we have Brian Pierce with MedRisk. We have Sasha Karshon with DeAndre Law. We have Chris Bowen with Work Comp Resolutions. And I'm Wendy Stevenson, I'm with MacroPro. And we have today our moderator, who is Diane Cohen. She's our Vice President of Client Services at MacroPro, and she's going to be the moderator. She'll be answering, she'll be grabbing all the questions that you ask, and she'll be asking those questions when it's time for the speakers to have the questions at the end of their presentations. So we'll go ahead and start with Brian. He is going to talk about telerehab. Brian, can you give us a little bit of information on what you have?
Absolutely. Happy to be with you. My name is Brian Pierce. I'm a physical therapist by trade, and I'm the clinical director at MedRisk. And my responsibilities are clinical oversight for our network of providers, and I oversee our telerehabilitation program. So for those of you who are not familiar, telerehab falls under the umbrella of telehealth. Telehealth is kind of a general term for all types of healthcare delivery that happens from a remote intervention. Most of us are a little more familiar with telemedicine, which would be delivering physician care remotely, and telerehabilitation would be delivering physical therapy, occupational therapy, or speech therapy remotely. So while it seems counterintuitive to be able to deliver such a hands-on service like physical therapy from a distance, it's actually quite popular in other places around the world. There's parts of Europe, Australia, and actually the UK, particularly where telerehabilitation is very widely accepted because there's limited access in those areas. In the United States, delivering care in this manner is a little more rare, particularly in areas, we see it in areas where physical therapy is not able to be accessed on a regular basis, usually because the patient is remote, like in parts of Western Texas or in Alaska, where there might not be a therapist within a reasonable proximity. Or it could be situations where the patient is homebound and can't really get out to therapy. They'll have physical therapy via telerehab in the home. So what we're doing now is taking a program that we've had in place for multiple years and actually pivoting a little bit to actually ease some of the burden on physical medicine during this times of the pandemic. So we started this program a few years back, and we used it as a point of creating some injured worker convenience and satisfaction by bringing the care a little bit quicker and more accessible to the injured worker. So we had a program where we would move patients from an in-clinic experience to a telerehab platform, similar to like what you're seeing now, when either they had a circumstance that necessitated it, perhaps they traveled a good bit for work, or perhaps a health circumstance that left them homebound and they needed to have care in the home. So the interface that these patients have is similar to what you're seeing here. They would meet with a therapist, and the therapist would perform some level of evaluation and then work them through a physical therapy session. Obviously, this looks a little different than it does when you have someone in front of you in an in-clinic experience. So a lot of what we were doing was modifying regular evaluation techniques and treatment techniques to something we could do without physically laying hands on the patient. So you'd be surprised on how much you can get done from a distance when you're forced to. So there are a certain number of evaluative techniques that we can use to assess patients from a distance and then work them through a rehab program. If you think about the physical therapy experience, part of it is active and part of it is passive. Most of the passive components, like having a therapist manually work on you or performing a physical examination, those are things that tend to happen towards the front end of the rehab experience. Whereas the more active components of the program, the exercise and functional training, tend to be a little bit more towards the tail end when someone is approaching a return to work. So what we were doing was taking the active approach and using that to be delivered via telerehabilitation. So once someone had their pain under control, had their mobility somewhat restored, we would move them into this telerehabilitation program if they were interested and if they were willing to connect and able to connect. We could create this convenience for them and deliver care in that manner from a distance, with it being primarily exercise instruction and guidance on self-care, activity modification, things along those lines. What's happening right now in the light of the pandemic is that patients are having difficulty getting to clinics, which may be closed, or it may be that they're fearful of leaving the home and they're in the absence of care. So what we've been doing is moving our telerehab program a little bit further up in the process and using it as an end-to-end solution. So we're doing a little bit more evaluation on the telerehab side than we had before. So we now have patients going from beginning to end on telerehab or using telerehab as to pick up where the in-clinic experience left off. And soon we'll be using it to bridge them back from telerehab into the clinic as things begin to open up. So one of the major concerns that we wrestle with is this effective? Does it work for these patients? And I can tell you that it does. And we based our program on being able to select the right patients at the right time, which is really critical to finding success. So we looked at all the research that's been done in other parts of the world. When care is delivered this way, the findings from the research are that the outcomes, if you select the right patient at the right time, are equivalent to in-clinic care. Now, during these times, we're not able to necessarily cherry pick the right patients that'll fit at the right time because there's some patients who just need to go into this delivery of care in order to ensure some continuity as they recover. So we have some patients who aren't exactly tailor-made for telerehabilitation. So we'll see how their outcomes pan out over time. So far, things have been going very well. We're finding a high level of satisfaction from the injured workers who are going through this process because it's bringing the care to them and leaving them in the situation where they can decide when they need to leave the home, as opposed to feeling the pressure to go visit the clinics if they have some concerns. And that varies obviously in different parts of the country. The other piece of this that helps leverage the experience is that the patients are a little more engaged in the process. When you deliver care this way, rely a little bit more on asynchronous care. So when you're going to physical therapy in a clinic, oftentimes you're given instructions and guidance on the things that you need to deliver, you need to execute at home, exercises to perform between sessions, or ergonomic modifications to make, or activity changes that you need to make to ensure your recovery and return to work. In the telerehab setting, there's a lot more interface between the therapist and the injured worker between sessions. So we have a portal that the patients access where we can upload all types of information for them there to continue to monitor their care or engage in their care a little bit more independently. And they can be autonomous as they look through videos on how to guide them through exercise, or tips on things like sleeping for positioning for sleep, or guiding them through different use of different modalities, etc. So what we found over time is that delivering care this way seems to be very effective and received very well by the injured worker. The trick now is making sure that we're able to continue as we expand the program to accommodate for the increased demand during these times with more patients opting to be homebound. So what we're looking for going down the pike here is making sure that we have a solid strategy of when it's safe for someone to go back into the clinic or when they're best served in telerehab. So it's a matter of balancing the severity of their condition versus their the safety, the risk that's involved in having them go out to the clinic. So you can imagine if someone had a mild injury and the recovery was going quite well, they could finish out in telerehab. But we obviously have some patients who are a little more severe conditions, and we have to move them from telerehab into the clinic to ensure they get all the care they need before they go back to work, because perhaps we weren't able to get them all the way back to return to work just through the telerehab experience. So I hope that paints a little bit of a picture for what's going on in physical medicine for those patients who need to get back to work but have not yet completed their course of rehabilitation. So at this point, I will open this up to questions if anybody has any regarding rehabilitation.
Yeah, hi. I have a question for you. How is it comparable between telemedicine rehab and being in a brick and mortar building? Is the results comparable? Are they similar? Are they far apart? What can we expect?
Sure. So what you find is for about 85% of the patients, you can get an equivalent outcome if you have the right trained therapist and you have them lining up with a patient who's compliant and engaged in the rehab process. Obviously, a little bit more of the onus becomes on the injured worker to get themselves through the process with the guidance of the physical therapist, as opposed to the hand-holding that you can do when someone is in the clinic. So what we're finding is a very large percentage of the patients will get equivalent outcomes, but there will be some outliers. You know, imagine someone who has just had a major surgery, like a knee replacement surgery or rotator cuff repair, something along those lines, where there's really a focus on the manual stretching that might be involved to help restore mobility, or the functional training that it might take to really put heavy weights in that person's hands to allow them to build up the strength they need to get back to work. In those circumstances, we can't get them all the way to full recovery by just telerehab alone. So for those cases, we need to transition at some point to some in-clinic care for some more aggressive functional training, or earlier on to make sure they have the manual stretching that they require. But for the overwhelming majority, if the patient is compliant and the therapist is fully engaged and they're leveraging the technology the right way, we can get equivalent outcomes in most of the cases.
Excellent. Are these sessions video recorded? And if so, how is that being used?
So it's a good question. So we have the ability to record the sessions, and we've specifically picked a technology platform that would allow us to do that, because we weren't sure. You know, obviously things are really evolving in telemedicine, and at this point they're really accelerating quickly, and things will look a lot different when we get on the other side of this in a few months. So we wanted to make sure that we had the ability to record the sessions if we needed to. If that became something from a legal standpoint or from a payer request standpoint that we needed to have the ability to do. At this point, we do not record them as a matter of routine. However, I will tell you that since we have the ability to do it, we leverage that in making sure that if there's opportunities to record something that will enhance the overall patient experience, we do so. So you can imagine a scenario where you and I are going through some exercise and I'm demonstrating some techniques that I want you to engage in, or I'm explaining something that I want you to remember and continue as you return to work, or a certain position to assume for relief. Those are things that I can record myself demonstrating that or explaining that, and I can upload it to the patient portal so it's available for you to review later. So would I record a full session? No. Do I have the capability to? Yes. But what I do record is small snippets, and then I do that if I need to make that available for the patient to expedite a return to work.
Great. Thank you so much.
Sure, my pleasure.
Fantastic. Thank you so much, Diana and Brian. Stick around, Brian. We'll have a few final thoughts at the end. Our next speaker will be Sasha, and he is with DeAndre Law.
Good afternoon, everyone. My name is Alexander, or Sasha Karshan. I am an attorney with DeAndre Law at the Oakland office, covering primarily San Francisco and Oakland venues. So I think the biggest issue from a legal standpoint with regard to COVID-19 is, of course, AOE COE, right, for claims handling. We already know that about 1,500 claims have alleged industrial exposure to COVID-19. They have already been filed. The 1,500 is, of course, out of 36,000 cases in California. So percent-wise, it's not everybody who has tested positive is filing, and some people who have not yet been tested have filed. So this number will grow. The question is by how much. With regard to the initial determination of whether or not coronavirus is in fact an occupational disease, we need to initially start the analysis by looking at an old Supreme Court case called Marsh versus IAC, and later I believe in 1998, elaborated in La Tourette versus WCAB. And that case stated that an ailment does not become an occupational disease simply because it is contracted on the employer's premises. It must be one which is commonly regarded as natural to, inherent in, and incident and concomitant of the work in question. For example, catching the flu at work has been found a non-occupational disease, but our inquiry would not simply end there. The case is not simply dismissed with prejudice and everybody moves on with their lives. This virus is novel, hence the name. So the primary question becomes whether there is a special and or increased risk from the nature of the employment. This is what the case of Bethlehem Steel suggested, placing the burden on the applicant to establish that the workplace subjected the employee to some special exposure, an exposure that's different from the public at large. In the case of Bethlehem, employees working in shipyards had contracted a contagious eye disease known as keratoconjunctivitis. And although the defendants in that trial showed evidence that the disease was also epidemic in San Francisco and the public at large, the Supreme Court found evidence convincing that the disease in the community outside of the shipyards was a much lesser proportion compared to those shipyards. It found the epidemic in the shipyards constituted a special exposure in excess of that is common in public at large. So at this point, I must urge, if you have direct contact with your employers, it would behoove them to keep detailed records of efforts undertaken to prevent or at least mitigate against any further spread of COVID-19 for those industries still operating in public. For example, what sort of signs and posts do they have? Have they offered gloves, disinfectant, masks, etc.? Have they implemented distancing practices within the facility where workers continue working? It would be less than ideal to also have to deal with potential serious and willful claims or Cal OSHA violations for the insured. There's presently no presumption of compensability, as for example, there is for a duty belt presumption for police officers claiming an injury to the lumbar spine. Frankly, I'm not sure we need a presumption, as this certainly feels like a situation of I'll know it when I see it, with regard to which industries pose a higher risk and which do not. The custodian or a janitor, for example, who cleans up a grocery store all by himself at night after the store has closed, especially with a mask and gloves on, should not be exposed to a larger risk than the public at large. He should definitely not be lumped into a larger category of grocery store employees should a presumption be introduced. Again, because such presumption would be overbroad and place unnecessary burden on the system. There has been some talk that Governor Newsom is intending to roll out an emergency measure which would make it strict liability. In other words, if a worker who's continuing to work in public has tested positive and files an industrial claim, it is automatically accepted. It is not a presumption, a rebuttable presumption. It is automatically accepted. I believe this would be a sweeping measure, completely overbroad and over-inclusive, and callously looks for other deep pockets aside from the state itself. So how high is the exposure risk in a particular industry? This once again returns to the case of Bethlehem Steel. Was the exposure of this particular job greater than the public at large? Did employment expose the worker, and how was the employee exposed? Arguments can of course be had on both sides with regard to nearly every type of employment. Furthermore, when looking at the risk at work as compared to the public at large, exposure in most public settings right now with the shelter-in-place restrictions is significantly lower, thus making much of the still operating industry likely to meet the burden of finding the exposure greater than the public at large. But on the other hand, the handful of people now working to keep a restaurant afloat by offering takeout and delivery, for example, are probably adequately distanced and spread out at the facility that the present exposure may be similar to the risk of contracting the disease simply walking around the sparsely populated streets. I think the most glaring cases of AOE-COE will of course be healthcare workers. This class is not only working in a dense population, but they're working with an acutely high volume of COVID-19 positive patients. Next, I believe we have a category of essential workers such as public safety, including police, fire, and EMT, sanitary and trash collection workers, grocery store clerks, delivery personnel, etc. We then have various other occupations with high exposure risks due to the density of population within which they work, but that have been deemed non-essential and have since either stopped working altogether or are working from home. I'm thinking of teachers, gig economy workers, such as those that work at stadiums, directly with Rudy Gobert, work at concerts, restaurants, travel and leisure industry. They would, of course, have the burden to backdate their exposure to before they were sheltered in place. What is the causation hurdle for all other workers? Well, ultimately, it's going to come down to the boards and the individual judges, and I sincerely hope that common sense rather than emotional appeal will rule the day to control the AOE, COE determinations. I'll now shift a little bit of focus to some of the benefit and indemnity implications during shelter in place. So there's a variety of different scenarios and fact patterns, each likely with their own legal implications for indemnity triggers. And I'm specifically thinking about injured workers that were injured prior to COVID-19, but now, because of the restrictions and shelter in place, are having to not work. So scenario number one is an applicant was on temporary total disability and just recently was given restrictions which the employer would have been able to accommodate except for the shelter in place. I believe that under these circumstances, the employee had not yet been brought back to modified duties and temporary total disability should continue. Somewhat different scenario would be an injured worker already returned and working on restrictions, but now the business has temporarily closed. He's seemingly off work for non-industrial reasons akin to unemployment. However, in these circumstances, I think it would be important to analogize to reasons behind the unemployment. If injured workers are accommodated and then terminated for cause, temporary disability is not thereafter owed. If, however, injured workers are terminated without cause, laid off, there's administrative changes in the business, temporary partial or temporary full disability may be owed depending on the restrictions. In our scenario, not only is the applicant for all intents and purposes laid off for no cause, but actually it is the employer because of the shelter-in-place restrictions that is unable to provide further work. Thus, if the applicant has not yet filed for unemployment benefits, I believe it would be wise to commence temporary disability. Now, what if an applicant was on temporary disability or on restrictions, which could not have been accommodated, but has now been released to full duties, though the employer is closed due to shelter in place? I believe at this point, had it not been for COVID-19 and associated shelter in place, the applicant would have returned to their usual and customary work. The cause of ongoing inability to return to work is clearly wholly non-industrial. And my intuition here is that the applicant needs to be notified of other state benefits such as EDD or FMLA. And in the meantime, temporary disability can be terminated and PDAs commenced. If the applicant has already been found MMI, whether or not they have returned, I see no need to start temporary disability because they're unable to return to work. I believe that PDAs should be advanced. There is a potential issue of temporary disability arising from an accepted COVID-19 case. It essentially becomes a question of how long until the applicant has recovered or, God forbid, passed away. And interestingly enough, considering that it's going to take a while for these claims to get litigated and accepted, if they are in fact found AOE, COE, the benefits are not going to be dispersed to the applicant contemporaneously with the need to receive those benefits. So they may be later on part of a settlement package, and presumably would just be the 4 weeks for the necessary quarantine or isolation. There's an issue of medical treatment for any applicant who proves AOE, COE of COVID-19, and this could be a significant expense, as hospitalization for 2 weeks could be in the 6 figures. Presently, aside from passing away, I do not see too many issues with permanent disability because with most patients, we see full recovery. However, if there's any residual disability, it would probably be under Chapter 5 of the AMA guides for any respiratory disease. Finally, I'm going to turn to some of the impact that the shelter in place has had on claims handling, specifically from a legal standpoint, and how I've been able to do everything remotely, and other attorneys, adjusters, and so on and so forth. For example, depots have either been continued. I've had some applicant attorneys that specifically do not want their clients appearing by video and would prefer an in-person deposition. So in those circumstances, they're continued, but other circumstances, depositions are carried out over Zoom. I've had multiple depositions at this point, and I have found them to be very constructive rather than having to undergo extensive delays. And who knows when we'll be getting back to business as usual, if ever. I think over Zoom with the video, I am able to get a full indication of the applicant's presentation, whether or not they're having symptom magnification, malingering, or their general demeanor, which may or may not raise red flags for purposes of my discovery and litigation efforts. With regard to treatment and med-legal evaluations, these are similarly being done remotely, like Brian said, with regard to physical therapy. And with regards to treatment, I see absolutely no reason why we should be delaying any treatment. If the primary treating physician wants to carry out evaluations via video, even via the phone, it's better for us to have those, regular reports coming in to give us an indication of where the injured workers are at in their recovery. With regard to med-legal, this is trickier. There has been a QME, Dr. Bazat Ahmad. He's a pain medicine QME who's been somehow allowed in regular times to carry out his QME evaluations telemedically, and I have categorically objected to him for a variety of reasons, one of which is that I do not like his reporting, but the other being that courts have ruled that his evaluation does not fit within the framework of what we see as the scope of QME evaluations. He essentially has a chiropractor meet with the injured worker and then over video does the evaluation. I don't find that adequate. But when push comes to shove, right now we're dealing with a situation where all of our QMEs are either continuing the evaluations or asking for our approval for them to be done remotely via video. And it's going to have to be a fact-specific analysis of how desperate are we for the QME report. If the applicant is not yet at maximum medical improvement, has a very high indemnity rate, and we are anticipating that permanent stationary status should be right around the corner, then I think it may be worth going through the telemedicine QME evaluation. If, however, the applicant has already been found MMI, PDAs are being advanced, and we're in no rush, perhaps let's wait a couple of months and see if we can get an in-person evaluation. Finally, hearings. The board has granted all parties not so much opportunity, but has required all of us to appear remotely, be it expedited hearings, MSC's priorities. I haven't had a trial yet, but expedited hearings, I have filed exhibits, I have filed trial briefs for purposes of expedited. And I have to say that hearings have been going extremely smoothly. Everyone appears on time, unlike frequently I find waiting for applicant attorneys for a long time. At 8:30 or 1:30, whatever the calendar of the hearing is, the judges are taking roll call. So no attorney is daring to appear 30, 40, 50 minutes late. On top of that, as they take roll call, they expect the parties to have either there's a quick disposition or there's a disputed issue. So all parties are showing up prepared. And as a result, it is very expeditious and very efficient for the judges to be able to incentivize movement of cases. And I hope that after we're all done with this and released, that the board's actually earn some of the benefits we experienced involuntarily out of the shelter-in-place procedures.
Thank you,
That's
Sasha.
all I
I
have
think
today.
I
Any
think-
questions?
we do. I think we have a couple of questions, Diane.
We actually got one by text. And Sasha, the question is, did you say that Newsom was going to pick up all of the coronavirus claims?
Yeah, so this is something that I heard on Friday, and I haven't. There was suspicion that he may be rolling something out this Monday. As far as I've been checking the news, he hasn't. And what was proposed is that he would essentially make it strict liability, which means that if an injured worker tests positive and happened to be working whenever the diagnosis is dated to, they would accept the claim. This is a preposterous proposition within the framework of workers' comp because there would be no rebutting it. You wouldn't be able to demonstrate, for example, that the injured worker has a relative that they live with who has tested positive. The claim would be accepted without any sort of opportunity to rebut AOE COE.
Yeah, thank you so much for answering that question.
So thank you so much, Sasha. If you could stick around, we would certainly appreciate that. Before Chris starts speaking, I do want to let you know that there are handouts. If you look at the panel that you can see as you watch this video, if you click on that panel, you can go ahead and click on the handouts. And if you need to have a copy of this slideshow, please make sure to email me. Chris?
Okay. Well, hi, everybody. And today we're going to discuss the WCAB and the current updates. So one of the things that's on the DIR website, so if you go to the DIR website, is a current status listing of all of the offices which are open in California and which ones are closed. Bakersfield and Eureka were the only two that were closed, and now Bakersfield is open as of last Wednesday. So everything is open except Eureka. So that's a good news. And when I say open, I mean virtually open, meaning some things you can do over e-filing, and we'll talk about that in a minute. So the other thing that's on the DIR website is a list of judges' conference lines. I know Sasha mentioned it for a brief second about conference call. We used to use conference call, and it was a $54 charge. Well, right now, there's a list of all 174 judges' phone numbers, and it's a toll-free number, so you're not being charged. And then there's a call-in line number. So you'll see that if you click on the list, which again is on the DIR website. If you go under, it's an Excel document, so it'll actually open in Excel for you. And then the last thing that's interesting in there is if you go to the DIR website and click on employer and injured worker updates, there's a section in there and they have links. For the injured worker, it's a benefit for workers impacted by COVID, paid sick leave, information on disability leave, paid family medical, and then pandemic unemployment assistance program. For employers, there's some links in there as well about reduced work hours, potential closures or layoffs, tax assistant, work sharing program, and then comparisons with California and federal laws and leave. So all of that is on the DIR website with links, so feel free to go in there and check that out. As of last Monday, so 10 days ago or 9 days ago, there is a list of what will be heard and what will not be heard at the WCAB. So the mandatory settlement conferences, priority conferences, status conferences, and all expedited hearings will still be heard with that electronic call-in telephonic numbers with the judges, as Sasha was referring to. All trials and lien conferences, though, have been continued. We had one that was April 30th, and it actually was continued to May 6th. So I'm not sure if the boards will be open May 6th. If not, I'm sure we'll receive another continuation, but at least they are continuing them and they are giving out dates, and the dates aren't that far away. So that's all good news. Now, these judges haven't worked telephonically and over email before, so be patient with them. A lot of them are used to being able to see people in person. It has been a couple of weeks now, about 4 weeks, that they've been working via email and telephonically over the teleconference numbers. So just be patient with them. They will get back to you. We're seeing turnaround times in a matter of days, not weeks, on approvals. So we'll let you know at the end of the conference call some of the information we do have on that. And then lastly, they are accepting electronic signatures on settlement documents, applications, pleadings, and petitions or motions. So what that means is we don't have to go out and get signatures. We can actually sign them electronically. If you don't have that capability, feel free to send it to us and we'll sign it for you and submit it electronically for you. Okay, now let's go on to the next topic. So the next topic is lien resolutions. And how is that going right now? Well, we're seeing actually more lien resolutions right now than we did before. And I think it's because now is a great time to reach settlement with the lien claimants. They're working, they're more willing to settle with you, I think, right now. We have seen actually an increase in the amount of lien claimants that are reaching out and offering to settle. A lot of the larger companies like Medical Lien Management, all of your favorite, they're offering to settle with one person, such as a supervisor, and then reach out to us. And we have 1 or 2 people here that work with that one supervisor over there, and then they hash it out and always seem to come to a really good agreement. So sometimes they'll try to ask you to do a consolidation. I'm not really sure you want to do that right now. Obviously, you'd have to get somebody else involved in your company to review all of them to see if there's a way you can consolidate for those liens in your office. But at least they are trying. And the main thing is just be careful right now. They're trying to push you to settle. They're thinking that you're sitting at home and you don't know, you don't have resources. They're trying to bully you. They're trying to scare you into saying that there's not a lien conference scheduled for the next 6 months or 9 months. If you have a good defense and you are already going to a hearing and you want to continue on that route, feel free, leave it out there because they are coming up. But if it's something that you want to settle, absolutely, go ahead and settle it. Use your same defenses. If it's bill review, use bill review. If you need a second opinion on bill review, let me know. We'll get that done for you within a day, actually. And then don't let them tell you things like, well, the defense attorney or the lien company, they're not answering their phone, so I just want to settle with you. We're all working, so we will answer our phones, we'll answer emails. Just continue with letting them know that we are handling the files and that they should call us if we already have the file. You don't want them bugging you. It's interesting, some of the stories we've heard since all this came up. Okay, so last thing is the walkthroughs. Lots of people have been asking about the walkthroughs. Walkthroughs are still being approved. Lots of walkthroughs being approved right now. The judges are working from home and they are responding to the e-filing and then via email. So it's like a hybrid. So it's just like going in front of the judges, except we're emailing them directly and then they're emailing us back with questions. There's some judges that aren't quite as patient, and if we send something in and maybe they don't like it or they have a question on it, they'll automatically set it for a status conference. But I'm finding the last 2 weeks, most of them are willing to at least send one email asking for information, and then we'll reach back out, get whatever we need back from you guys, and then we send it back and we're getting approvals sometimes within a day. It's amazing. I would say average right now about 2 days. There's 1 or 2 boards, it's 3 or 4 days, but for the most part, they're turning around very, very fast. Now is a great time to settle. A lot of these injured workers are home and they need the money, and it's a great time to ask them if they would like to settle, especially the ones that have previously been stipulated and they're open for future medical care. Now is a great time to reach out to them and ask if they would like to settle via CNR and get their checks to them. Will help you get the voluntary resignation letters as well. You have to be careful with some of these doctors. I know that some of the injured workers who were just getting ready to settle, all of a sudden they've returned to their doctor and they're back off work. So make sure you follow up with the doctors and check to make sure that that really is truly a temporary disability factor and that you should be paying it, because I know it's going to be questionable right now. People were uncertain how long it would take to get their furlough checks. So they thought, well, I'm already in the system with EDD, so I'll just go ahead and get back on temporary disability. We've seen a couple of those come in already, and we have to kind of get our way and feel our way through those. They're already in the system. So we had a case in chief file that was just getting ready to settle by CNR, and the person called and said they were scared about doing that right now because they didn't know what was going to happen down the road. So they wanted to leave it open. So again, just be careful on that. And then the last thing is, I know a lot of people are wondering right now, they're sitting at home, it's been 5 weeks. They're going over their priorities and their happiness level, and do they really like their job? And I think out of this, we may see one of two things. Either we'll see people come back to work and they'll love their job, they'll have a zest for it, and we'll see less injuries. I mean, when I say less injuries, I mean fault injuries. Or they're going to come back and think, well, I don't really like my job, so now's a great time to file a claim. So I'll be interested to see which way it goes and how it all plays out in the end. So if there's any questions, we can answer some questions right now.
Diane, do you have any questions for Chris?
Yeah, Chris, I'm just wondering, can you tell me what you're seeing as far as settlements are concerned? How many? Is it really different than what it was prior to COVID-19 hitting, or is it pretty much the same?
Well, for the lien claims, I actually think it's more settlements right now. We just reached 600 liens that we've settled since we've been working from home, which is amazing. I think the lien claimants are more willing right now to settle, as we discussed, so that's really great. And then on the settlement walkthroughs, I think it's about the same amount, but it's faster. We just settled 200 so far. We just passed 200 yesterday afternoon. There's probably more today, I haven't counted, but we're seeing them come in all day long from the judges. So it's amazing that these injured workers are getting their checks quickly, so it's wonderful.
Yeah, thank you, Chris.
Thank you.
Thank you, Diane. Thank you, Chris. So let's talk about getting records. We are very fortunate at Macro Pro. We had a pandemic plan in place, and we were able to execute it pretty quickly. We were able to get most of our employees working remotely, and we still have some employees working in the office. And as you can well imagine, we are practicing social distancing. We're cleaning between shifts and following all of the state mandates and guidelines, just as other essential businesses are doing. And because we had a pandemic plan in place, we were able to limit the downtime for our clients. Well, I've had a few questions recently, and folks have been asking, and I hear these questions daily, and some I hear more than once. And one of these questions is, can we still order records? Now, I'm sure that this will apply to all record retrieval company services. And when you ask, can we still get records? Absolutely, you can still get records. You can order your records, and so you know, there are quite a few people who are working diligently to facilitate the ordering process of records. And the big question out there, and this is the one that I hear most often from folks, is about the custodians. And are they working during the COVID-19 pandemic, and what can we expect? And here's what you should know about the custodians. When COVID-19 first came on the radar, prior to becoming a pandemic, the custodians were allowing non-employees into their offices. They were taking temperatures and screening them for fevers and coughs, and they were putting them in a little quarantine area, temporary quarantine area. And once they cleared the observation period, they were allowed to go in and scan records. The minute coronavirus became a pandemic, the custodians implemented their best practices and shut down the facilities to anyone who was not an employee. The thing to know here is we are still getting records, and we are still processing orders, but records are not going to be obtained as quickly as in the past. Imagine the amount of document retrieval services in California. There are well over 250 of them. Imagine if they were all scheduling appointments with all of the different custodians, and you can see the back up there. Imagine a line at the door to the custodian's office with folks waiting to get in to scan records. I recently went to Costco to pick up some essential items, and of course it was 6 feet apart, and I live in Sonoma County, so everybody wears a mask. And that line at 7 a.m. for Costco that didn't open until 8 a.m. literally wrapped around the building. And for those of you who've been to Costco, that's a really big building. And so that was a really long line. So if you can visualize the line to get records through those custodians, that's what you're looking at. Now, in regards to the custodians, there might be 1 or 2, sometimes 3 in each facility. They now have to do the work of all of those document retrieval services because they can no longer have these folks come into their offices. They're helping to process the orders on your behalf, and this means it's more like rush hour traffic at, well, say 4:45 p.m. on Highway 680 or 580 or Highway 101, or for those of you in Southern California, the 405. It's a lot of gridlock, and it's very, very slow. I don't know about you, but I've been in that traffic at 4:45 on actually probably all of those freeways. And there has been a phrase that's been used by our very own Diane Cohen at MacroPro. And she states, it's not business as usual at this time. It's business as unusual. It's important to remember that it's not business as usual when it comes to getting records from your document retrieval services. A little bit of patience is going to go a really long ways. So let's talk about the best ways to get your records. The best way to order your records and then to get them, the best way to order them is ordering them online. And the reason is when you key in the information, you're providing everything directly to your document retrieval company. It's in their system on their online ordering page. And once that's keyed in and everything is confirmed, at that point, we can begin serving the authorizations and the subpoenas. Now, things are a little bit different. We are serving by mail. We cannot serve in person anymore, and we believe this is best practices. We don't know if every facility will accept service by mail, but we feel that in order to do the best job for our clients, we have to get you in queue to get your records and the evidence that you need. Remember that big line around the block I was talking about a minute ago at Costco? Yeah, we want to jump to the front of that queue. And because we have employees working from home and limited employees in the office, we, like other copy services and document retrieval services, we don't have the manpower at this time to do what we used to do in days past, when you could just email the information on the records that you need, and someone would take that information, enter it into the system, and get it ready to be served. It can be done. We can do that for you, but it'll take a little bit longer. It can take days sometimes before that can happen. And that's depending on the volume of orders. And at this time, the volume, it's tremendous because people have time to request records right now. They're not running to grab a cup of coffee or having a long commute that may or may not have been similar to the 405 freeway or 680 or 580. And so having a commute that, as my daughter puts it, from in my house is 20 steps to my office in the back, that's not a long commute. So that gives people a great deal of time to do some of the things that they need to do for their files. And ordering records has been one of them. So if you can key your request for records directly into your record retrieval company's online ordering system, I think that's going to be your edge. Our customer service team is here to help. And again, we are a little short-staffed, as are all other document retrieval services. So remember, when working with your company that you work with to get your records, have a little bit of patience and give them a little bit of time to get back to you. And be patient while you're waiting for that phone call or your email. And here's just a little side note, be patient with your colleagues, your managers and your supervisors. Some of those two-legged colleagues that might be related to you that call you mom or dad. Everyone's going through this together. Even those little four-legged critters that might want to jump up on your lap or sit on your keyboard while you're trying to work. Customer service people working remotely don't have everything at their fingertips. They have that at the office, but they don't really have that when they're working remotely. So again, patience is the recommendation. And when it comes to records and records delivery, we believe that it's best practices to deliver everything electronically. We believe that for our clients at this point, and that's the best practices that we're taking care of at this time. You can either have a downloadable link emailed directly to you, or you can have the electronic file transfer that we have a lot of companies do. We don't know how long the coronavirus can last on services. And when we receive records from a custodian in paper form, well, there's a concern there for our employees as well as for our clients. So we've already set protocols with custodians to see if we can get paperless records. We're very fortunate that we have a top-notch IT department here, but not all copy services have that. So please know that things can take more time for some companies than others. And again, patience is really going to go a long way right about now. Our company is running from 3 a.m. to midnight every day, and that gives us time to have our offices cleaned between shifts and our system to update regularly. Also, if you need records nationwide, out-of-state records, state to state, you can still get them. Not all areas of our country are affected the same as California and New York, or say Louisiana or Colorado. So check with your record retrieval company. We happen to have a department that's overseen by a paralegal, and now is not a difficult time to get records out of state. Diane, do we have any questions?
Wendy, early on the pandemic, we did hear the president and his administration talk about lessening HIPAA regulations. Can you let our viewers know what that was pertaining to?
So you're correct, Diane. Whoever asked that question is correct. The HIPAA compliance was softened a little. It wasn't lifted, and it doesn't pertain to claims, and it doesn't pertain to records retrieval or document companies or evidence, etc. It applies more for doctors to have access to information more freely, have access to information more freely. They need to have that information so that they can treat somebody with all of their medical history. And if they have to go through the red tape and have to have this HIPAA compliant authorization signed and get that and get this, and you see how it is, they need to work at a pretty quick pace. And so it's important to get that information, at the snap of a finger. And so that's why it was softened.
Oh, very good. I see that we have 2 other questions that are being asked, and I will let our viewers know that I will get them to the proper expert, and we'll see if they can't reply to them via email, since we didn't have an opportunity to ask those questions when they were doing their presentation.
Okay, fantastic. So we are just about at the end of our presentation, but I do need to let you know about certificates. Certificates will be emailed directly to you within 36 hours of this presentation. It's important to remember that when you logged in through the registration confirmation, you were automatically put in as an attendee. So it's important to know that that's where your certificate is going to go, to that email address. So let's see here. We want to have a final thought. Brian? Hello, Brian.
Brian had you sent away. You have Carrie. Hi. Brian sent me his final thoughts. And basically, with the year, near universal access to Wi-Fi. Everyone's got tablets, computers, phones, anything like that. The technology has been available for telehealth, telerehab for quite some time now. And with COVID-19, it's really pushed us into realms we've never thought possible. Who would have thought we'd all be working from home at this point? And just so COVID-19 has pushed us into needing telerehab and telehealth more so than we ever thought possible. So embrace it. It's here. We're here, and we can assist with anything you need. So thank you.
Thank you. Sasha, do you have a final thought?
Sure. I think this has already been touched upon, but look, I don't know when we're going to get to back to business as usual. With a lot of these injured workers sitting at home, I think a lot of our claims that are ripe for settlement otherwise get stagnated or delayed just because an injured worker has the liberty to sit on it as much as they want. And I do not want to take advantage of those affected by the shelter-in-place restrictions, but for all the adjusters, look through your files and those either nominal claims or altogether denied bogus claims. Work on getting settlement authority now, whether there's been a depot, whether they're found MMI, whether there's been a med legal evaluation or not. There's always an opportunity to settle it if the price between the parties is right. And I believe under these particular circumstances, many applicants who know that they have a bogus claim may be willing to bite at nuisance value settlements. So not the truly sincerely large cases that do need to play out, do need their treatment, do need their med legal evaluations. But the nominal claims, I feel like now is as good a time as any to try to settle them.
Well, I just want to say that I'm very grateful and proud of all of our people working from home, the adjusters, the employers. Everybody has stepped up, and the people who have never worked from home before, it's definitely different. And you guys are doing a great job. So keep it up, and we are all here for you and support you.
Thank you very much, Chris. My final thought is to remind you of a best practice, which is to place your orders online. It places you at the top of the queue, and it helps to get your records as quickly as possible during this very unusual time. Diane, do you have a final thought?
I do. I'm going to say for all of you that use a medical authorization form as a normal course of business, I'm going to ask you to ditch that and start using a all-purpose authorization form, because that's going to broaden the places that you're able to get records from. For example, you can't get employment records from a medical authorization form. So if you don't have one, please let your copy service know, or let us know. We'll make sure that you get one so that you're not being delayed because you sent the wrong authorization form with your request. And then the other thing, Wendy put up this slide, I did a presentation at Work Comp Central. It's somewhat of a TED Talks. It is about the difference between overcoming our obstacles. We're always thinking that we can't overcome our obstacles, and yet we have so many accomplishments. It's just something for us to think about and ponder, because all of us are charged with making the injured worker better. So not only do we have obstacles, but so do they. So I hope you watch that and get a little inspired.
It's a very good presentation. I highly recommend those 7 minutes. Thank you so much, everyone. I just want to remind you that your certificates will be emailed within the next 36 hours. If you have any additional questions, please email. We're happy to answer them for you. Thank you so much to our experts. We so appreciate your time. Everybody have a good afternoon. Be well and stay safe.
Thank you. Hey, Carrie and Sasha, you both have questions in the queue. So if you guys want to grab those questions and reply back.